Offer or proposal. So according to section 2 subsection A, when a person signifies to other his willingness to do or to abstain from doing something, એટલે કંઈક કરવું અથવા કંઈક ના કરવું, with a view to obtaining assent, એટલે સામેવાળાની પરમિશન, સામેવાળાની મંજૂરી મેળવવાના પર્પસથી, of that other to such an act or abstinence, એટલે એ જે તમે કરો કે ના કરો એના માટે, then he is said to make a proposal or an offer. Means if you are proposing something that you want to do something or you don't want to do something with the purpose of obtaining the other person to whom you are making offer is called proposal. So intention here is to obtain assent. Assent means you can say permission, his willingness to do or not to do something. So that is called proposal or offer. It is one of the essential elements of a valid contract. Now there are different types of offer. Express offer. When offer is willingly conveyed to the other person in writing or in oral, you are willingly offering something expressly. Implied offer. When offer is given to another person not in writing or not by the words, but it is implied that you are offering. Every time you don't have to make an offer in an express way. Sometimes the offers are implied. Just I gave you an example, okay, whenever you are traveling by bus or train, it is implied offer by the bus company or traveling company that you have to purchase the ticket. They are not going to offer you, okay, whether you want to purchase a ticket. It is implied that you have to. Specific offer. When offer is given to specific person, it is not to the general public. It is targeted to specific person or group of person. General offer. When offer is given to entire world at a large. આમાં એક કેસ છે, એ તમને યાદ રહે તો ઠીક છે. કાર્લિલ વર્સિસ કાર્બોલિક સ્મોલ બોલ કંપની. અમુક કેસીસ જે હશે મેં આમાં હાઇલાઇટ કર્યા છે, યાદ રહે તમારા ક્વેશ્ચનમાં લખવા હોય તો લખવાના, અધરવાઇઝ વાંધો નહીં. So general offer, it is made to the entire world, to each and every person. Suppose newspaper માં કોઈ ad આવે, so it is general offer. If you have opened any shop or showroom and you are selling something, so you are offering your product to the general public, not to the specific one. Then cross offer, cross offer. When both persons are making identical offer to each other in ignorance of others' offer. Like I am also selling you mobile and you also want to sell me the same type of mobile, unaware of the other person's intention. Then counter offer. When a person to whom offer is made, instead of accepting the terms of the offerer, desires modification of the same. If I offer you my mobile at 10,000 rupees, then you will say, okay, no, will you sell it to 8,000 rupees? So what offer I have made to you, you are offering in some other way. There is counter offer, modification of offer. આટલામાં નહીં આટલામાં આપશો બોલો. Standing offer, an offer which remains continuously enforceable for a certain period of time. આપણે સપોઝ કોઈ પ્રોપર્ટી સેલ કરી, બરાબર, એનું ટોકન મની આપ્યું, so during certain time period the offer will be valid. After completion of that time period, the other person, if does not act upon that, the offer will come to an end. સ્ટેન્ડિંગ ઓફર, હજી ચાલુ જ છે. લાઈક ઓનલાઈનમાં કોઈ સેલ આવે, the sale will last within 24 hours. So within 24 hours, if you are not exercising that option, it will come to an end. Till then, it is standing offer. It is still valid. So this is the case. Carlyle versus Carbolic Small Ball Company. That the advertisement was not a unilateral offer to all world, but an offer restricted to those who acted upon the terms contained in the advertisement. Satisfying condition for using the smoke ball constituted acceptance of offer. Means if you are acting upon the condition mentioned in the advertisement, it is implied that you are accepting the offer. That purchasing or merely using the smoke ball constituted goods consideration, and more people buying smoke ball goods by relying on advertisement was a clear benefit to Carbolic. Means when you are enjoying the benefit, when you are using that thing, then later on you cannot deny that we have not accepted. You are actually using it, you actually gain the benefit, so you acted upon the offer. So it is that the offer was general and you acted upon it. So companies claim that 1,000 pound was deposited at the Alliance Bank showed the serious intention to be legally bound. So whenever you are entered in any transaction regarding that offer, it will be construed as accepting the offer, which was a general one. This is just for your information. Just you have to, possible if, then you have to memorize the case and mention in the question of offer. Then legal rules regarding offer. Offer must be given with an intention to create legal relationship. Intention is to create legal relationship, not personal social relationship. Whenever you are offering something, your intention to obtain assent, acceptance of the person to whom you are offering. Offer must be definite, clear. It must be clearly stated that what you are offering, what you are proposing. There is difference between offer and invitation to offer and invitation to sale. You are inviting somebody on the basis of terms and condition. You are inviting somebody so that you can sell, so that is not an offer. But specifically you are conveying what you want to sell, what you want to exchange, then it is offer. Offer must be communicated. It has to be conveyed to the person. Communication offer is complete only when it reaches the person to whom it is made. It has to be in writing or oral. Like it may be in form of advertisement, it may be in form of email, letter, message, phone, whatever mode of communication it is. Mere statement of price is not an offer. હું એમ કહું કે મારા મોબાઈલને તો 20,000 આવે એવા છે. So that does not mean I am ready to sell it at 20,000. If I specifically told that I want to sell it at 20,000, then I am offering it. Just mentioning the price is not an offer. એ કેસ આપણે નથી important. Now, acceptance. So when a person made a proposal to another, to whom proposal is made, હવે એનો counterpart offer ની સામે acceptance. So when a person made a proposal to another, એક માણસે બીજાને કંઈક offer કર્યું, proposal આપ્યું, if the proposal is assent thereto and the other person to whom the offer was made has accepted it, has given his consent to do or not to do something, then it is called acceptance. Acceptance must be absolute and unconditional. It should be clear, without any condition. If you are accepting, that means that you have accepted all terms and conditions. You cannot put another condition that we will accept only if so and so condition will be satisfied. So then it may or may not be valid for the person who has offered. Acceptance must be given as per the mode prescribed by the offerer. If it is specifically asked that you have to accept in writing, you have to intimate whether you accepted it, then it should be in the prescribed mode. If I have received an offer through mail and it is specifically asked that I have to reply through a mail, then I have to. When it is specifically asked, I have to give my consent in writing, then I have to give my consent in writing. Then it will become valid acceptance. Acceptance must be given before lapse of time or within reasonable time. The time તમને આપ્યો કે આટલા ટાઈમમાં you have to convey whether you want to act upon it or not. તમારો જે બી રિપ્લાય હોય હા ના, પછી તમે લટકાઈ રાખો એ ના ચાલે. It has to be accepted within reasonable time or within given time. In certain case, the time is fixed. Beyond this date, beyond this month, you have to accept it. And in certain case, the time will be decided on the basis of circumstances of the transaction. Acceptance may be given by any person in case of general offer. When offer is made in general, it may be accepted by any person. But if offer was made to a specific person, then only that specific person can accept it. Acceptance must be given by the person to whom the offer is made or by his authorized person. એટલે મને કઈ વસ્તુ ઓફર કરી હોય તમે, so it has to be accepted by me or by my legal authorized representative, not by any other person. Acceptance must be communicated. It may be in words or in written. Mental acceptance is no acceptance. હું મનથી નક્કી કરી દઉં, મારા મગજમાં વિચારી લઉં. How the other person will come to know what decision I have taken. So mere mental acceptance or readiness, state of mind is not acceptance. Or acceptance must not be derived from silence. Acceptance must not be precedent to offer. Counter ના હોવી જોઈએ. જે કીધું છે એના સિવાયનું નહીં. Now communication of offer and acceptance. The communication of offer is complete when it comes to the knowledge of a person to whom it is made. The communication of acceptance is complete as against the proposer, offerer, who is making the offer, when it is put into a course of transmission to him so as to be out of power of the acceptor. એક વખત એને કહી દીધું, then offer has been made. Now he cannot revoke the offer. No. Once you have specifically told and the other one is accepted, you have to act upon it against the acceptor when it comes to the knowledge of the proposer, the person who has made the offer will come to know whether the offer he has made has been accepted by the person to whom it was made or not. Now revocation of offer and acceptance. Rad batal karu, cancel karu. The proposal may be revoked at any time before the communication of acceptance is complete. એટલે communication complete થાય એ પહેલા તમે વચ્ચેથી અટકાઈ દો, then it is okay. But after the offer has been communicated to the person who is going to accept it, you cannot revoke it. Once it has reached to the person, you cannot revoke it. Now you have to act upon it. Same way, the acceptance may be revoked at any time before the communication of acceptance is complete as against acceptor, but not afterwards. If you have accepted something, if you have given your assent, then you can cancel it, you can revoke it before it will reach to the offerer or proposer, not after that. Like M buy a letter posted on 1st June offers to sell his car to N for 5 lakh. The letter reaches N on 3rd June. N accept the offer by letter posted on 5th. The letter reaches M on 7th. So date is important. Beyond that date, whether offer or acceptance cannot be revoked. Communication of offer 3rd June. Communication of acceptance as against proposal 5th June. As against acceptor is for 7th June. So proposal can be revoked before 5th June and acceptance can be revoked before 7th June. Now, lapse of offer. Breach of offer. Lapse એટલે છટકી જાઓ, मतलब ભૂલી જાઓ. Or you can say when offer comes to an end. So by revocation, specifically the proposer or offerer is revoking before it becomes communication against the proposer. Before the specific time, the offer has been cancelled or revoked. Then lapse of time. Beyond the prescribed time or reasonable time, if offer was not specifically accepted by the person to whom it was made, then it will come to an end. Then death or insanity of offerer. Proposer hoy, offerer hoy, any death થઈ જાય. The person who has proposed is dead or is become incapable mentally to perform his part of obligation. So death, physical or mental incapacity to perform on the offer will put an end to the offer. બરાબર, જે પર્સને તમને ઓફર કરી એ પર્સન જ ના હોય, then or that person has become mentally or physically challenged. Now he cannot perform his duty, perform his part of promise, what he offered. Then counter offer. What I am proposing you, you are proposing the same. Instead of accepting, you are also offering me. So it means that you don't want to accept. If I am asking you certain question, instead of answering it, you are also asking me the question. It means you don't want to answer. It is the same thing. Acceptance not as per prescribed mode. It was specifically asked you have to accept the offer in writing or you have to give your reply via email. But rather than that, you acted upon differently. Then you cannot tell that I have accepted. You have to act upon the offer, you have to accept the offer, and you have to communicate the acceptance in the prescribed mode. Otherwise, it will come to an end. Destruction of subject matter. The subject matter for which you have made a proposal, made an offer, will come to an end. Then automatically, now how the contract will be made? The subject matter, the purpose, the objective has been distracted. It is not available longer. Then it will come to an end. Rejection of offer by offeree. The acceptor, the offeree to whom we have made an offer, will specifically reject. I don't want to act upon it. Then it will come to an end. See, B offered to sell his house to A for 50,000 rupees. A accepted the offer by post. On the next day, A sent a telegram revoking the acceptance which reached B before the letter. પહેલા એને ઓફર કરી, પહેલા એક્સેપ્ટ કરી અને પછી બીજા છે ટેલિગ્રામ કર્યો કે ના 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 હવે મારે નથી વેચવું. Is the revocation of acceptance valid? What will the effect if both letter of acceptance and telegram of revocation reach B at the same time? Original offer letter and revocation offer બે same time એ મળે તો શું એની effect થાય? See, revocation of acceptance is valid because acceptor may revoke his acceptance anytime before the letter of acceptance. જ્યાં સુધી acceptance of letter પહોંચે નહીં ત્યાં સુધી revoke કરી શકે. If both the letter and telegram of revocation reach B at the same time, the formation of contract will depend upon the fact which of the two is opened first. બે લેટર આયા મારા હાથમાં, હું પહેલો કયો ઓપન કરું છું? હું પહેલો એ ઓપન કરું કે ભાઈ જેમાં ઓફર હતી અને હું એક્સેપ્ટ કરી લઉં તો કઈ ના થઈ શકે. પણ હું પહેલો એ લેટર ઓપન કરું કે જેમાં રિવોકેશન હોય તો હું કદાચ બીજો લેટર જોઈશ જ નહીં. If B reads the telegram first of revocation is valid, but if the letter is read first, the revocation is not possible. Capacity to contract, capacity of parties. So as per section 11 of the Indian Contract Act, every person is competent to contract. He is qualified to enter into any legal contract who is of the age of majority, means who has attained the age of 18 years or more, who is of sound mind, who is in a proper state of mind at the time of entering into contract, and is not disqualified from contracting by any law which he is subject. Certain person who has disobeyed law or disobeyed anything or who are subject to any legal proceeding may not be allowed to enter into any type of contract. Suppose a person who has become bankrupt or insolvent cannot do any type of legal contract. He is disqualified by the Contract Act or by any other law. Okay, a person who has committed any crime against whom any case is pending, proceeding is going on, or he has been convicted for the same crime, then he cannot enter into any legal contract. Now, contract with minor or position of agreement with minor, legal rules regarding contract with minor. So who is minor? So in general sense, the person who is not of the age of 18 is called minor, and the person who has attained the age of majority, that is age of 18 years, completion of 18 years, is called major. But in case of property, the same age will be 21. So if we are talking about any real estate property, then majority will be attained on completion of 21 years. In any other case, it will be 18 years. So minor, person of unsound mind, alien enemy. Alien enemy means the person who is living in a country with whom we are at war. Suppose today it is declared that India and Pakistan at war. Then both the citizen of India and Pakistan are alien enemy for each other. They cannot enter into any type of contract. Then person who is declared insolvent, bankrupt, like Vijay Mallya, Nirav Modi. Then convict, who has been convicted for any other crime. So he is specifically disqualified from entering into any type of contract. Any company, any corporation against his memorandum of association or article of association cannot enter into any contract. If in the memorandum of association or article of association, it is specifically mentioned that the company cannot enter into specific type of contract, then it cannot. So there is a celebrated case, Mohri Bibi versus Dharamdas Ghosh. બરાબર, આ તમારે ખાસ યાદ રાખવાનું, બહુ જ important. In that case, the decision given by court that agreement with minor is void ab initio. Minor જોડે કોઈ પણ ટાઈપનો એગ્રીમેન્ટ કે કોન્ટ્રાક્ટ કર્યો હોય, it is invalid from the very beginning. Doesn't matter minor accept કર્યો તો, minor એની મંજૂરી આપી હતી નથી આપી, doesn't matter. But agreement with minor is void ab initio, invalid from the very beginning. હવે કેસમાં હતું શું કે D, a minor, borrowed a sum of money from M by executing mortgage of his property in favor of M. એટલે M ડી એમ પાસેથી પૈસા લીધા, એની પ્રોપર્ટી મોર્ગેજ કરી. Subsequently, Dharamdas Ghosh D sued for setting aside the mortgage. So, M prayed for refund of amount by the minor, but it was held the money advanced to minor cannot be recovered because minor's agreement was void. પૈસા બી નહીં મળે અને પ્રોપર્ટી બી નહીં મળે. કેમ કે તમને ખબર હોવી જોઈએ at the time of giving loan on mortgage that any agreement, any contract with the minor is void ab initio. ચાલે જ નહીં. તમારે જોઈ લેવું જોઈએ ને, માગવું જોઈએ ને એનું આઈડેન્ટિટી પ્રૂફ, એજ પ્રૂફ, that you will come to know about the real age. પછી આવે minor can be a beneficiary. Any contract which is for the benefit of minor are valid. Minor can be a promisee but not promiser. તમે માઇનર ને કઈ આપવાનું હોય, માઇનર ને કઈ મળવાનું હોય, એના માટેનો કોન્ટ્રાક્ટ વેલિડ છે. બટ માઇનર પાસેથી કઈ લેવાનું હોય, then they are not valid. So minor can be a beneficiary, then they are valid. Such contracts are valid. Minor cannot ratify the agreement on attaining the age of majority. Suppose a person at the age of 15 years entered into any contract. The same contract was void ab initio because it was the contract with minor. Now after attaining majority, that is after 18 years, if the same person will say that I will validate the contract, then it is not possible. He can enter into new contract, but the contract which was invalid at that time cannot be ratified. Ratified એટલે પાછળથી સુધારો, પાછળથી accept કરું to make it good. It is not possible. They can enter into a new contract but cannot ratify the old one. Then he can enter into contract for his necessary. A person who has supplied the necessary to a minor or those who are dependent on minor is entitled to be reimbursed from the property. એટલે માઇનર ને એવી કોઈ વસ્તુ એવી કોઈ સર્વિસીસ પ્રોવાઈડ કરી હોય which are necessities, which are basic life necessity required for the survival of one's life, એને necessity કહેવાય. તો એવું કંઈક એને સેલ કર્યું હોય અને માઇનર પૈસા ના આપે તો માઇનર ની જે પ્રોપર્ટી હોય કદાચ હોય તોની વાત છે, તો એમાંથી રિકવર થઈ શકે. બટ એના માટે માઇનર ની અગેન્સ્ટ પર્સનલી કોઈ કેસ થઈ શકે નહીં. તો નેસેસિટીમાં ફૂડ, ક્લોથિંગ, શેલ્ટર, એજ્યુકેશન, all these are necessities in India. Claim has to be against property, not against the minor. એટલે માઇનર ને કઈ આપ્યું હોય અને એની પાસે પ્રોપર્ટી હોય તો એની સામે ક્લેમ કરી અને પ્રોપર્ટી વેચીને પૈસા વસૂલ કરી શકાય ફોર નેસેસિટી. હા, પણ પૈસા ના હોય, પ્રોપર્ટી ના હોય તો માઇનર ની અગેન્સ્ટમાં પર્સનલી કેસ ના થાય. ઇન કેસ ઓફ મેજર પર્સનલી કેસ થાય પણ માઇનર માં ના થાય. What is the liability of minor's guardian in this case? The parent or guardian of a minor cannot be held liable unless those goods or services are supplied to minor as the agent of parent or guardian. એના માટે માઇનરના ગાર્ડિયન કે પેરેન્ટને તમે જવાબદાર ના બનાવી શકો unless and until એના પેરેન્ટ્સ કે ગાર્ડિયને એના થ્રુ એ ગુડ્સ કે સર્વિસીસ લીધા. If it is not directly supplied to minor, then nothing can be done. Then આમાં નથી બીજા. No estoppel. Estoppel means you cannot stop him from getting the benefit of his minority. A minor is not estopped from setting up a plea of minority. Suppose I have entered into any person who is minor. At that time, he didn't specify that he was minor. But later on, he will say that I am minor. I cannot say that earlier you said you are not minor and now you are admitting you are minor. You cannot stop him from getting the benefit of his minority. He can get the benefit by pleading his minority. બરાબર? એ તો એમ કે હું તો માઇનર છું, મને થોડી ખબર હતી, છટકી જાય, તમે કઈ ના કરી શકો. Then minor can be a shareholder because shareholder is the beneficiary. He is going to receive the share or dividend. So minor can be a shareholder. Minor cannot act as a partner. He can be a partner for profit only. Suppose A, B and C are three partners running a partnership firm. Now C died due to any reason. Now D, who is C's daughter, who is minor. Now A and B cannot admit D as a full-fledged partner, but they can admit D as a partner who is minor, who will share only profit. So in case of loss, only A and B will share. But if there is profit, it will be given to D also. Then later on, after attaining the age of majority, now D will decide whether she wants to continue with the partnership or not. Minor can act as an agent because agent is not a party to a contract. Agent is just a mediator. He is representing the other person. So there is nothing wrong or illegal to become an agent because agent in any act does not possess any personal responsibility or liability. Agent, broker, mediator, and the same thing. So minor can become an agent. A minor cannot enter into legal contract, but he is punishable or liable for any other criminal activity or torts. આપણે કોન્ટ્રાક્ટ ની વાત કરીએ છીએ, પણ કોઈ માઇનર હોય જેની પાસે લાયસન્સ ના હોય બરાબર, ટ્રાફિક પોલીસ પકડે, હેલ્મેટ ના પહેર્યું હોય, લાયસન્સ ના હોય, તો એના પર કેસ થઈ શકે. એવું ના થાય કે હું તો માઇનર છું, મને નથી ખબર. કોઈ માઇનર કોકનું મર્ડર કરી નાખે અને પછી કે હું તો માઇનર છું, એ ના ચાલે. સો ફોર એની ક્રિમિનલ ઓફેન્સીસ પનિશેબલ અંડર ઇન્ડિયન પિનલ કોડ. હા, એના માટેની પનિશમેન્ટ અલગ હોય. જ્યુવિનલ કોર્ટમાં ચાલે, જ્યુવિનલ પ્રિઝનમાં લઈ જાય, નાના છોકરાઓનું હોય એમાં, મોટા જોડે ના રાખે, બટ સ્ટીલ દે આર લાયબલ ફોર punishment for criminal offense.